Good afternoon and welcome to this Regulatory Transparency Project webinar. My name is Sarah Bankson and I am Associate Director of RTP here at the Federalist Society. Today, June 12th, 2023, we are pleased to host a discussion entitled Utah versus Walsh, latest developments and the challenges to the DOL's ESG rule. After the discussion, our panel will take audience questions, so please submit those into the Q&A function at the bottom of your Zoom window. Please note that, as always, all expressions of opinion on today's program are those of the speakers. Now, to introduce our speakers, today we are joined by Jared Kelson, Counsel at Boyd & Gray and Associates. He worked previously as an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice, where he received the Attorney General's Award for Distinguished Service. Mr. Kelson is counsel for Plaintiffs Liberty Energy Inc, Liberty Oilfield Services LLC, and Western Energy Alliance. Our moderator today is Brett Swearingen, Associate in Miller Johnson's Employment and Labor Practice. He previously served as counselor to the Deputy Secretary at the United States Department of Labor. At the DOL, he was a key advisor on several important rulemakings, including regulations concerning ESG investing. In the interest of time, I've kept my introduction short, but you can read the full and impressive bios for both of our speakers at regproject.org. Thank you all for joining, and now I will hand it over to you, Brett.
Thank you, Sarah, and good afternoon, everybody. Again, I'm Brett Swearingen, and I come to this issue because I was at the Department of Labor when the first ESG rule, which was promulgated in November of 2020, was passed. I was highly involved in that rulemaking, so that's why I'm here. And because this is a bit of an esoteric issue, I wanted to do, before we hand off to Jared to talk about the litigation, I wanted to do a quick set of slides giving kind of background on both ERISA and ESG. So without further ado, let me do that, and I will try to be relatively quick. So the first Department of Labor regulation on ESG was promulgated towards the tail end of the Trump administration, November 2020. And of course, we have a new rule that the Biden administration promulgated that came out late November, early December last year, and that is the rule that is being challenged by plaintiffs, which Jared represents. So tonight, or this afternoon, I'm going to talk about ERISA and ESG, the rules. Jared's going to provide a litigation update, and then we will move to Q&A. Okay, just to be clear what we are not talking about today and what we are talking about, ERISA concerns only private sector retirement plans, which means we are not discussing just personal investing. We're not discussing IRAs. We're not talking about public employee retirement plans. We're also not going to be offering opinions on the merits of ESG investing, whether financial or otherwise. This is purely about the law concerning the regulations. We're also not going to be mentioning the big SEC climate disclosure rule that should be coming before too long. Okay, ERISA is the law that Congress passed in 1974 to regulate private sector employment plans. Basically, there had been a series of catastrophic failings of the system where people had an employer go bankrupt and lost pretty much their entire pension. ERISA is designed to prevent that. Probably the core protections that ERISA provides in that regard is applying what are called fiduciary duties to plan fiduciaries. And that makes sense. We have people who are managing other people's money that is intended to help you retire, help your spouse retire, help your children have a future. So these fiduciary duties put very high standards on what you can do and what you cannot do when managing that money. These standards are so high that some courts have called the standards in ERISA as the highest known to law. Next slide, please. So in terms of ESG and in terms of the rulemaking that Jared will be discussing, two standards are relevant, and they are known as the duty of loyalty and the duty of prudence. Here I'm going to quote from ERISA. It's section 404. The duty of loyalty requires fiduciaries to act solely in the interest of the participants and beneficiaries of the plan and for the exclusive purpose of providing benefits to participants and their beneficiaries. Adding a little bit of color to these words, in 2014, in a case called Dudenhofer, the Supreme Court, in the unanimous decision, said that the term benefits that I just quoted refers to financial benefits, such as retirement income, rather than non-pecuniary benefits. So in interpreting the duty of loyalty, courts have used quite strong language. They say it requires fiduciaries to act with complete and undivided loyalty to beneficiaries, and for their fiduciary decisions to be made with, quote, an eye single to the interests of the participants and beneficiaries. Now, I think this language raises the question of whether ERISA is providing a motives test. I think that's an interesting question of the law. Regulators and courts don't like motives tests because obviously motives are secret, but I would argue that the language of ERISA 404 that I just quoted is in fact saying you must be motivated solely in the interest of plan participants and beneficiaries. But that is kind of an outstanding and interesting legal question. Next slide. The other ERISA loyalty or ERISA standard we're discussing is the duty of prudence. The duty of prudence requires fiduciaries to act with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent man acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims. A lot of words. It's also known as the duty of care. This basically means you need to act confidently. You need to make sure you've done your diligence. You need to be taking good care of people who are under your responsibility. Next slide. Okay, now we're moving to ESG. ESG, for those who are uninitiated, stands for environmental, social, and governance. It's kind of new, not super new. It's certainly been getting a lot more steam, which is why the prior administration decided to do a regulation on the topic. The biggest issue in the discussion is typically climate change under the E, but as you can imagine, those are very broad words, especially the S for social, so lots of things can fall under ESG. So any investment strategy that takes these factors into account can be described as ESG. Again, ESG is kind of a recent nomenclature, but the idea has been around for decades. Just some previous uses of the idea include social investing, SRI, socially responsible investing, ethical investing, economically targeted investing, sustainable, responsible investing, impact investing. Basically, the idea of using money that's invested in ways that either is intended to produce benefits besides returns, or is using other factors as a way to maximize financial returns. But it's an old concept, but a kind of a new vintage. So the reason that this has become an issue in the space of ERISA, why there's been dueling rulemakings now, is, as you may have guessed, there's an inherent tension between at least some forms of ESG investing and ERISA. Again, if you are using ESG in a way that is intended to provide benefits that are not strictly benefits that are good for the plan participants in their pension and their families, but are intended to provide environmental benefits or social benefits, that inherently raises a tension with the duty of loyalty and the duty of prudence that I just mentioned. Again, that is why this has become a very live issue in the ERISA space. Next slide, please. Okay, so DOL is involved because they are the agency, through the sub-agency, the Employee Benefit Security Agency. They are in charge of implementing ERISA along with the IRS. So a brief history on this issue. Almost as soon as ERISA was passed, the Department of Labor was under pressure to permit various groups to use pension assets. Pensions were the major retirement plan at that point, for various causes. And even if you go before the passage of ERISA, so if you look at the legislative history of ERISA, there were people during the committee hearings and the markups that were asking for language to be put into ERISA that would allow, to some extent, ERISA investments to be used for not purely the interest of the plan. Obviously, those requests were denied when Congress did pass ERISA in 1974. I read you that language. There's no carve out. I didn't skip any carve out that allows, various kinds of collateral investing. In 1980, a famous speech by the then director of the benefits office at the DOL gave a speech, where he said, quote, economic considerations are the only ones which can be taken into account in determining which investments are consistent with ERISA standards. And he warned that fiduciaries who exclude investments for non-economic reasons would be, quote, acting at their peril. Plaintiffs in this case also found a very interesting law review article from 1980, same year as this speech, that looks at the issue of what was then called social investing and gives a very thorough analysis and concludes, you know, the language in ERISA is just, it's very tight. There's really not room for social investing for talking about ERISA. But anyway, point is, basically the history of ERISA is also the history of people asking for permission to use ERISA assets for quote unquote non-plan purposes. Okay. Over the last 30 years or so, beginning certainly in 1994, there's been kind of a ping pong in how various administrations have approached this issue of ERISA and ESG or social investing or economically targeted investing. 94 was the first formal guidance that was issued. The shorthand is, and some of you probably already know this, but Democratic administrations have used softer language when describing ERISA's fiduciary duties. Republican administrations have used more strident language in describing those duties. And there's been, as we've seen in other spaces, a kind of regulatory ping pong. The key thing to point out here, which is very relevant in the litigation that Jared will talk about, is in the guidance, beginning in 1994 especially, there became, what was introduced was what's known as the tiebreaker rule, also known as the all things being equal test. And this became the kind of accepted way that the Department of Labor said you can consider non-strictly financial benefits. We use the term collateral. You can consider collateral benefits if you're an ERISA fiduciary only if you're making your investment decisions, you're analyzing potential investments, and you find a tie. You find two or more investments that are equally good, you know, in terms of a risk return analysis, they're equally good. In that case, you can quote unquote break the tie on the basis of that collateral factor. Again, this is called the tiebreaker rule. It first appeared in formal guidance in 1994 and has remained since then. Again, there's been shifts in how stridently the administrations have described it. So the most recent guidance before the 2020 rule was at the end of the Obama administration in 2015. Next slide, please. Okay, so here's where I got involved. Again, ESG was becoming increasingly popular, and at the Department of Labor, we saw the risk that fiduciaries would not be using or not be living up to their full obligations under ERISA, and we decided to do a rulemaking mainly trying to clarify the application of those fiduciary duties in ERISA 404 to this growing field of ESG investing. Next slide, please. Okay, so one of the things DOL did in 2020 is copy the term that had appeared in the Dudenhofer case in 2014, where it referred to non-pecuniary benefits. And the 2020 rule employed this term, non-pecuniary, not everybody's favorite phrase. And the regulation said ESG, sorry. The reason we use non-pecuniary and pecuniary is because ESG is just a slippery concept, so we concluded it is not a clear or helpful lexicon for regulatory standard because it resists precise definition. So again, we use pecuniary and non-pecuniary, defining pecuniary factor as a factor that a fiduciary prudently determines is expected to have a material effect on the risk and or return of an investment. Probably could use the term financial as a fine synonym. So under the 2020 rule, plan fiduciaries' evaluation of investments, quote, must be based only on pecuniary factors, end quote. Next slide, please. The 2020 rule also narrowed the tiebreaker rule as it had been previously expressed. Under the 2020 regulation, fiduciaries are only allowed to break the tie with non-pecuniary factors, collateral factors, if they are, quote, unable to distinguish between the investment options on the basis of pecuniary factors alone. So that was a narrowing of the language of the tiebreaker rule. Basically, a fiduciary doing his or her best job trying to decide which is the best investment for a plan. If that fiduciary cannot decide which is best, then he or she is allowed to break the tie with a non-pecuniary factor. Next slide. Okay, so importantly, as Jared will cover more, the 2020 rule, although it was interpreted to the contrary in many outlets, did not prohibit consideration of ESG factors or even the inclusion of an ESG fund on a 401k plan menu. Frankly, ERISA would not allow us to do that. ERISA says you have to do what's best in the interest of the plan. It doesn't comment on specific types of investments or categories of investments. The rule only said that in order to consider an ESG fund or ESG factors, those factors have to be pecuniary, material to whatever investment you're considering. That's because ESG factors in and of themselves can be pecuniary or they can be non-pecuniary. It all depends on the particular investment in question and the facts and circumstances. Again, this has been a point of confusion in the popular discussion, though it's not really ambiguous if you read the 2020 rule, but anyway, Jared will say more, I'm sure. Okay, I think we're moving on to the 2020 rule, or sorry, 2022 rule. So that came out this past winter. It states that fiduciaries may but are not required to consider ESG factors when evaluating an investment, provided they're economically relevant to the investment. Quoting from the reg, risk and return factors may include the economic effects of climate change and other environmental, social, or governance factors on the particular investment. Similar idea as what you've heard me describing, but they're not using the words pecuniary and non-pecuniary anymore. They stripped those words from the regulation itself. Okay, so here's just a quick chart between the 2020 rule and the 2022 rule. Again, the 2020 rule talks about pecuniary, non-pecuniary in terms of whether you can use ESG. The 2022 rule explicitly talks about ESG factors, but says you can only use them if a fiduciary reasonably determines that the factor is relevant to risk and return. The tiebreaker rule, so the 2020 rule narrows it. Fiduciary has to be unable to distinguish competing investments based on pecuniary factors. I didn't mention this before, but you also had to document under the 2020 rule how you broke the tie with the non-pecuniary factor if you did so. The version of the tiebreaker in the 2022 rule says that non-financial factors may be considered when competing investments equally serve the financial interests of the plan. And the 2022 rule deleted the documentation requirement when breaking ties. The 2020 rule had some rules on when you can use ESG funds in a QDIA. That was stripped in the 2022 rule. As to whether you can take into account participant preferences, some participants who specifically want ESG investments, say on their 401k menu, the 2020 rule said you can use those preferences as a tiebreaker if you have two plans of equal merit that you're unable to distinguish. The 2022 rule said that that is explicitly allowed as long as it is part of a prudent process by fiduciary. Okay, next slide, please. Okay, just to summarize, I think it's important to recognize that under either rule, 2020, 2022, Trump administration, the Biden administration, whether a particular factor, if you're a fiduciary looking at what investments to include in a plan and what investments to make for a pension fund, it is not relevant at all whether you're looking at an E, S, or G factor unless you're in a tiebreaker situation, which I think we all would recognize that the vast majority of cases, it's just not something that matters from a fiduciary perspective, whether something is E, S, or G. Again, kind of ironic given how much we talk about it, but that's a good, helpful summary. But here's the rub. How many ties are there in reality? And I think part of what's going on between these dueling regulations is a skepticism towards whether ties really occur with any frequency. And then on the other side, there's ties are the way that you can consider collateral factors. So I think that's part of the push and pull here. Okay, I think we have one more slide left. This is just a nice map to show that probably why all of you are on this call is because ESG has become kind of a cultural phenomenon. It wasn't so much 2 or 3 years ago, but this is as of November 22, so it's already a little bit old, but I count almost 2/3 of states, one way or the other, have adopted ESG legislation, either pro or con. So it's just become a very, very live issue in the culture war. And we're not here to fight the culture war. We're here to talk about ERISA and litigation. But anyway, it's just interesting to see how ESG has kind of come so far so fast. With that, I'm going to turn it over to Jared. Jared is playing a very big role in the litigation that is challenging the current ESG rule. So all you, Jared.
Thanks, Brett. Just to start off before we get into discussion, I'd just like to kind of give a general idea of the scope of what this rule covers. There are 152 million workers in the United States who have these private retirement plans covered by ERISA. That's roughly 2/3 of the US population of adults. We're looking at about 12 trillion in assets. The amount of money at issue here is substantial, and it reaches into houses across the country. Similarly, if you look at the plaintiffs in this case, there are 26 states that are a part of this lawsuit. There are energy companies, there are energy trade associations, there are private individuals. This rule is far-reaching in as far as the interest that it affects, to the point that a majority of states in this country have found the rule sufficiently problematic to file suit. Just as to kind of continue a little bit of what Brett was saying, the fiduciary duties here are also, as he pointed out, the highest known to law. The Fifth Circuit has held that explicitly, and that's particularly relevant because that's the circuit that we're in. A lot of these fiduciary duties, the courts have used various formulations, but they all say the same thing, that they require complete and undivided loyalty, single-minded devotion, that fiduciaries can't be influenced by any motives other than the accomplishment of the purposes of the trust that they're managing, especially that includes social and political issues. So this is a very interesting confluence of factors here. We have a lot at stake. It affects a lot of people. It affects a lot of states and a lot of governments. And we're dealing with the highest duty to take care of the pension funds of American workers to make sure they maximize their financial returns so they have a means of surviving once they stop working. I can keep going, Brett, or if you have any questions specifically that you want me to address, either way is fine.
Did you have more you want to provide about the litigation?
I mean, I can go into more detail if there's specific questions. I'm happy to go either way.
Okay. Yeah, we can go into questions. So Jared, I think the core legal question in the overall litigation is what I talked about with some extent in my little update or background, is the tiebreaker rule. And in particular, what is the relationship between the tiebreaker rule and those high fiduciary duties that are included in ERISA. So plaintiffs, they argue that the tiebreaker rule is necessary because there's a gap in ERISA. That's the word they use in their briefing. Sorry, the defendants. And in a certain sense, they're right. ERISA does not explicitly say what you do if you're a fiduciary and you're looking at your investment options and you think there's a tie. The ERISA does not explicitly address that. On the other hand, I express my position that it is a motives test, and there's just not any room in ERISA to ever make a decision motivated by anything other than the plan participants and beneficiaries. So I wanted to give you the chance to comment on what is plaintiff's position on the tiebreaker rule as you're litigating.
Got it. So back in 1941, I think, and since then, the Supreme Court has reiterated that a fiduciary can't say that when it has conflicting interests, that it served its masters equally well, or that its primary loyalty was not weakened by the pull of a secondary one. So the idea behind these fiduciary duties is that, to put it colloquially, no man can serve two masters. There's a concern that even when there's a hierarchy to these priorities or to these objectives, whenever there's a secondary objective in the background, it will either overtly or subvertly influence any other priorities. So for this reason, trust law, it adopts a default rule. I'm going to read from the third restatement of trusts. But the purpose of these fiduciary duties is to remove the occasion of temptation for fiduciaries rather than monitor their behavior and attempt to uncover or punish abuses when they succumb to temptation of a secondary motive. So rather than monitor and make sure that they're doing things right, the whole point is to prevent them from having any sort of secondary considerations altogether. that would suggest that no matter what the circumstance is, you can't have a collateral consideration. That would indicate that the tiebreaker is not lawful. That the idea that there are times or there are exceptions when you can consider these secondary motivations as inconsistent with the law of trusts, which is adopted into ERISA. It's inconsistent with the language of ERISA that the sole benefit that fiduciaries must act for the sole benefit of plan participants. To the extent there is a gap, that gap would be exceedingly narrow. It would be only in situations when you have no other considerations, no financial or pecuniary considerations to rely on. I think that's the standard the 2020 rule was trying to articulate, this idea of economically indistinguishable. Now, the Department of Labor, both in 2020 and again in 2022, said, well, there's so many financial considerations. There are so many things to take into account that true economically indistinguishable is rare if it exists at all. There's so many other things to take into account. We don't think that any two investments are exactly identical. Well, if that's true, which is the department's position, then the tiebreaker doesn't really exist. There's always going to be some other consideration to make. You don't need to revert to a secondary one, to a collateral consideration. But leaving open the possibility that there are indistinguishable attempts, then maybe you could justify the tiebreaker there. But it seems to be contrary to the language of ERISA, which does not allow for these secondary considerations at all, for these collateral considerations, and it seems to be contrary to the law of trusts. Just to kind of connect those, the Supreme Court has been very clear that ERISA adopts the law of trusts. So we have both the language of the statute and the background fiduciary law of trust that say that you can't have collateral considerations, that we don't want to risk fiduciaries being influenced by them, whether it's subconsciously or overtly. We don't even want to have to pay to monitor it. It's just not appropriate. You only look at the benefits to the participants, and those benefits are their financial interests in securing the best retirement possible.
Thanks, Jared. As you know, I tend to agree. We've had a question from the chat. I think it'd be helpful. Just can you give us the status of the litigation, where things stand as of today?
Yeah. So right now we're about to conclude briefing, and at which point the judge, we're down in the Northern District of Texas, will obviously consider the arguments. The case started out in the posture of seeking a preliminary injunction. However, as the briefing concluded, it seemed pretty clear that the case could be resolved pretty quickly. And so the parties agreed to move straight into briefing on summary judgment and a potential trial on the merits if necessary in front of the judge. So that briefing is almost concluded, at which point the court will consider the arguments and if necessary, schedule an argument.
Thank you. So I wanted to ask about kind of the factual premises that lie behind both the 2020 and the 2022 regulation, because I think this is kind of interesting just from an administrative law perspective, because they were released basically 2 years apart, and they in a way have almost opposite factual premises. So the regulation I was part of drafting, we were concerned that there was a risk of overeager adoption of ESG as an investment strategy in instances where it would not comply with those fiduciary duties. That was the concern that we were addressing. That was the factual premise of our rulemaking. The factual premise of the 2022 rulemaking is that the stringent rules that we adopted in 2020 have the risk of limiting fiduciaries from actually investing in ESG investments, or at least considering ESG factors in a way that could actually hurt participants, because it would mean plans are denied the opportunities for certain investments that could actually be economically beneficial. So kind of the opposite premise. How should a court looking at this take account of that fact when you have the same agency in 2 years kind of having a completely opposite view of the factual lay of the land?
Well, the Supreme Court's been pretty clear that facts and circumstances change. That seems to be a pretty uncontroversial proposition, that facts and circumstances change, and sometimes agencies need to respond. But the Supreme Court has been equally clear that when an agency changes the factual premise of a rulemaking, it needs to explain why. And more specifically, in a case called FCC v. Fox Television, the Supreme Court said that agencies must provide a more detailed justification when the new policy rests upon factual findings that contradict those that underlie its prior policy. So if the agency is essentially going to be finding contradictory facts or changing the facts that it relies on later on, changing the factual basis for the rulemaking, it needs to provide a more detailed justification than maybe it would if it was writing on a clean slate. In this particular case, as you mentioned, in 2020, the department said that the department observed that some fiduciaries weren't necessarily being as stringent in observing their duties as they should be. And so it promulgated this rule and said to emphasize that fiduciaries should focus on pecuniary factors. They should focus on risk and return. And to the extent considerations would affect those, weighing that risk and return calculation, then they should be taken into account. In 2022, the Department of Labor came back, starting in 21 and then in 22, Department of Labor said, well, we think the language in the old rule was chilling people. It was chilling and causing fiduciaries to shy away from ESG investing. And that could potentially hurt participants in the marketplace, plan participants in these retirements. So we need to redo the rule and see if we can get rid of that chilling effect. The proposed rule in 21 actually weighed heavily in favor of ESG, and it had a lot of language suggesting that ESG was a necessary consideration. It could be simplified as a very pro ESG regulation. A lot of commenters pointed out that ERISA is not an ESG statute. ERISA is about maximizing returns, and that this pro ESG posture may not be consistent with those fiduciary duties. So the department scaled it back a little bit in 22, but still came out and essentially said that ESG factors can affect financial returns, and they started to loosen the language. It wasn't nearly as stringent as the 2020 rule. And the justification for this again was that, well, the old rule was, the language was too strict, or the language was too strident and was chilling ESG investing. To support that proposition, they cite a few letters from asset managers, some from people that are not fiduciaries at all, who said, there's a chilling effect. What's notably missing from the record, though, is any indication that this was actually hurting plan participants, that this had actually diminished the returns on financial portfolios. I would assume that if this was really hurting the financial performance for plan participants, that was something that would have been all over the rule. But the department didn't produce any of that sort of indication. They just said, we think people are being chilled, we're changing course, and we're promulgating a new rule. It's not clear to me. In fact, I don't think that satisfies the more detailed justification to change course here. The record's just really scant on that particular point. It also is going to run its intention with a number of other things that the department has said. For example, at the beginning of this rulemaking process, the president issued Executive Order 13990. This was right after he had assumed office, President Biden, in 2021. And he said that the policy of his administration was to listen to science, to improve public health and protect the environment, to reduce greenhouse gas emissions, to bolster resilience to the impacts of climate change, to prioritize environmental justice, and the creation of well-paying union jobs. So taking this, the Department of Labor turned around and said, we're not going to enforce the 2020 rule anymore. We're going to start new rulemaking and see if we can replace it. The interesting thing is that Executive Order 13990 has nothing to do with return to the financial benefits of plan participants. In fact, it has everything to do with the president's climate agenda. And that was the basis for DOL to stop enforcing the 2020 rule and to re-engage on this rulemaking. So to the extent that the department had to provide a more detailed justification for why the facts changed, there's not a whole lot in the record that support its proposition that A, fiduciaries were being chilled, and B, more importantly, this was actually hurting plan participants. In contrast, there's a lot of evidence in the record that suggests that there was an ulterior motive here, and that was to open the door for ESG investing.
I just wanted to add for more context, for those who don't know, there's a sizable movement in the kind of environmental investing ESG space for mandatory ESG, especially if you look at what's going on in Europe. So on one side, there's people that say a fiduciary is violating his or her duties by not integrating. That's the term you see, integrating ESG. Again, these are people that are not operating under ERISA. So what they mean by fiduciary is not necessarily an ERISA fiduciary. But anyway, that's just the far side of this debate that we're talking about.
Yeah,
So we've got
real quick, Brett. In the rulemaking, also, there are statements that there were concerns from some commenters that the United States, and especially this ERISA fiduciary standard, was not consistent with emerging norms in other areas of investing, including international norms and expectations about addressing climate change and responsible investing. And the department seemed to credit those statements that this was a concern or that this was a valid consideration. That has nothing to do with maximizing returns for plan participants. ERISA is all about maximizing returns so that the participants in these plans have retirements.
We've got a question from the comments on proxy. I know we're not talking much, but do you want to just talk a little bit about the proxy piece of this and the, yeah.
Sure. So the new rule makes a number of changes, and in one aspect, you have to look at each of these changes individually to see why the department's making them. But if you zoom out, there's a consistent theme throughout the new rulemaking, and this will tie into the proxy voting. The consistent theme is a general lack of concern for participants and for their returns, and a greater concern for making decisions easier for fiduciaries, for protecting fiduciaries when they decide how to invest, and to give them latitude to consider alternative factors. In the 2020 rule, it included a requirement that if a fiduciary was going to exercise proxy rights, that it had to document those decisions. That way it would be very easy for plan participants or other fiduciaries even to make sure that these proxy rights were not being used in a manner that was incompatible with ERISA. The 2022 rule removed those record-keeping requirements, decided they were too burdensome on fiduciaries and they should be able to exercise proxy rights. The interesting thing about that decision is now it's going to be very difficult to figure out what a fiduciary is doing with the proxy rights of the plan participants. To be really clear, the fiduciary doesn't own any of these proxy rights. These are the proxy rights of plan participants. But now the fiduciaries can exercise those. They can vote on shareholder proposals. They can, without any sort of record of what they're doing, at least a record that they're keeping that can easily be accessed by the plan participants. Similarly, the rule initially was going to include a requirement that whenever a plan participant or whenever a fiduciary considered some sort of collateral factor, whenever they considered some sort of ESG to break a tie or for any other reason, that they had to note that on the investment option. So that way plan participants would know that this had been a consideration in the background. But then the Department of Labor decided that that rule too was too burdensome and needed to be removed. So on one hand, the Department of Labor is consistently loosening the fiduciary standards, allowing a greater access to the tiebreaker, specifically countenancing the ESG factors in the rulemaking, saying, yeah, these might be very material, and then simultaneously removing all the record-keeping requirements. So that way fiduciaries can act in a manner that's going to be very difficult for the participants to keep track of, very difficult for the courts to look at, very difficult for other fiduciaries to also monitor. It seems to be that everything's pointing the same direction, that the Department of Labor is very encouraging, consistent with President Biden's agenda of allowing this money to be reallocated into ESG funds.
Kind of piggybacking off that comment, Jared, it raises another, what I think is an interesting administrative law piece of this, and that is kind of the disjunction between, say, the de jure aspect of the reg and then the law, and kind of the de facto effect of the new reg. And by that I mean, you can argue, I think it's not an invalid argument, and amicus in your case has made this argument, that because a lot of the key fiduciary standards are still in the 2022 rule, a phrase you'll see all over the place in the 2020 rule and in the 2022 rule is that fiduciaries cannot subordinate the interests of plan participants and beneficiaries to other objectives, and that's certainly a true statement. That's consistent with ERISA. Obviously, they're still operating under ERISA, the fiduciary duty, straight out of Section 404. So you have this, high fiduciary language that is still in the regulation. Though, as you said, beneath all those standards, they did cut out lots and lots of the safeguards that had been in there from the 2020 rule. And it seems clear, at least I would argue, that even though all these high-level standards remain in place, the language of ERISA has not changed, that the intent is to have a substantial change on fiduciary behavior. When this rule was published, there were press releases from all corners of the administration, from Congress. It seems like they want this to have a big effect. They want this to loosen fiduciaries to make more investments on the basis of ESG. So that's my question. On the one hand, you have a lot of these same standards still in the text of the regulation. On the other hand, you have all these indications that despite those standards, the actual intent of the rule is different. And they're hoping that on the ground, in the world of ERISA plan fiduciaries, that this will make a sizable difference. And again, what is a court to do with this kind of complexity and subterfuge? That'd be the bad faith way of approaching it. Yeah, can you comment on that?
Yeah, so I think I hear two different questions. The first one is how should the court balance when perhaps the de facto and de jure effects of a regulation, or like what the regulation says versus what the real world effect that regulation might have. And then the second question would be the department is seeming to emphasize that this fiduciary duties are still there. How do we reconcile that with the fact that that everyone seems to sense that this is actually going to be a significant change in fiduciary law. So if I understand that correctly, I'm going to start with the first question. In 2019, Chief Justice Roberts wrote an opinion in a case called Department of Commerce versus New York. And one sentence of that opinion stands out and seems particularly relevant here. He said that even when review of an agency action is deferential, the courts are not required to, quote, exhibit a naivety from which ordinary citizens are free. The courts don't have to put their head in the sand and pretend like they don't understand what's going on. They can look at the real world implications of what's happening. They can look at all the factors that are weighing on the agency's decision and the background against which it was promulgated, and they can make an informed decision based on that. In this particular case, as mentioned earlier, this rulemaking started in response to an executive order from the president about trying to address climate change, about trying to pursue his climate agenda. There's additional language in a lot of these things about trying to satisfy our commitments under the Paris Climate Agreement, even though that agreement is not binding on the United States because it's never been ratified by the Senate. So, taking the chief at his word in this case, like the court should be looking at all these different factors in the background. The court should also be looking at the rule as a whole and recognizing that when you're systematically loosening these restrictions and removing all sorts of record-keeping requirements, everything's pointing in this direction of removing the oversight and allowing for ESG considerations in ESG or in ERISA fiduciary, in the ERISA fiduciary context. That bleeds into the second question of, did this really change the standard? At different parts of the Department of Labor's rulemaking, they say over and over again, like, fiduciary duties still apply. These are still like very strict fiduciary duties. We're just trying to clarify the rule. We're trying to clarify what the fiduciary duties require because of this chilling effect. That justification or that explanation to me seems very problematic for a few reasons. Number one, the department concedes that under the 2020 rule, you could consider ESG factors if they had a material effect on the financial proposition of an investment, on its return, on its risk return calculation. So ESG was not forbidden under the 2020 rules. It was simply limited to when it would have a material effect on the investment. If that's the case, then it's not clear why the department wanted to go through a year and a half of rulemaking, responding to thousands of comments to say, well, this rule says the same thing as before. We just wanted to clarify that ESG investing is okay. That could have been accomplished very easily with a short guidance document saying, we've looked at the rule and consistent with what we said in 2020, ESG investing is permissible if it affects the risk and return, financial return of the portfolio or of the investment. But the agency didn't do that. The agency expended significant resources. The agency expended significant time, significant taxpayer dollars to write a new rule and push it through the rulemaking process. That would suggest to me that the standard's not the same, that something had to have changed in the rule. And the fact that it changed the language is another indication that there's something about equally serving the interests of the portfolio or equally serving the interests of the participant, which is the new language, versus economically indistinguishable for the tiebreaker. But that language is different. One is more loose than the other. Second, and this ties both of them together as well, Congress passed a joint resolution disapproving of this rule. It was a bipartisan vote of Congress saying that something was wrong with this rule and it should be invalidated. The only reason the rule took effect is because President Biden vetoed that joint resolution. So it seems pretty clear that the Department of Labor thinks something changed, or it wouldn't have gone through this process. And President Biden thinks something's changed, or he wouldn't have needed to veto the regulation. Congress clearly thinks the rule is different. And so I don't understand. It's not clear to me why the judiciary should think that this is the same standard either. The other two branches of government have both spoken, and they don't think it's the same. The only time that the department has expressed the idea that, well, the fiduciary duty still applies in the same way is in litigation, or is in like very cursory sections of the rulemaking. Then when it then continues to go on and explain why fiduciaries were discouraged because the tiebreaker was too hard to satisfy. It was too hard to find tiebreakers. It was unnecessarily stringent. And so they needed more flexibility to find tiebreakers. ERISA does not allow fiduciaries to, it's not allowing fiduciaries to find tiebreakers. You know, in the rare chance there's an economically indistinguishable one, fine. But they shouldn't be, but fiduciaries should not be looking for tiebreakers. They should be looking for best-in-class investments. So if that's the case, then first of all, the first question is, the court should be able to look at the entire context, including the backdrop against which this rule was promulgated. And then second, it's very difficult for the government to argue that these are actually the same standard, given the amount of time and effort and resources and different language that's gone into it. A few more points on that second consideration. Sorry, I just drew a blank. Well, let's go to the next question. If it comes back to me, I'll circle back.
No worries, it may come back to you. We've gotten some good questions from the chat. Somebody asked, why aren't plaintiffs lawyers bringing cases when ESG investments lose money? I just thought I'd throw in there, the first plaintiffs lawsuit that I think has been filed was filed last week or maybe 2 weeks ago by, actually I don't remember who it was by, but the target was American Airlines. So it could be the first of many, but you know, that's a good question. Okay.
So Brett, just I guess related to that question, this is, now that there's been a lawsuit filed, I think it's helpful. This shows kind of what the rule's doing in the background. First of all, like these lawsuits probably haven't come as much because this rule just took effect at the end of January. So it's a timing issue, number one. Number two, without the record keeping requirements, it's going to be really hard to show that there was an actual breach of fiduciary duty, because first of all, you have to know that ESG was a consideration. The Department of Labor has taken a somewhat confusing position that these collateral consideration, that ESG is sufficiently relevant that fiduciaries can consider them in making these decisions, at least in breaking ties, but that they don't need to tell the plan participants about it, that they're not important enough that they can affect the way plan participants view their portfolios or make their own financial decisions. It seems a strange proposition under trust law, that almost to turn trust law on its head, that somehow something can be relevant to the fiduciary but not to the participant whose interests are actually at stake. And that might be one of the reasons that these lawsuits haven't been coming as much, or at least that they're just barely starting up, is because without record keeping, it's going to be difficult to know what happened. Relatedly, when the Department of Labor amends its rule and specifically says that ESG factors can affect material performance of stocks, it allows fiduciaries to point to the rule and say, look, like the Department of Labor thinks this is material, and go on its merry way. And so that in some ways, it looks like this rule is intended to run cover for fiduciaries if they choose to pursue ESG investing.
Two questions relating to the way plaintiffs are arguing this case. One, can you talk about how you think the major questions doctrine applies to plaintiff's position? And also the question about the grant that ERISA gave the Labor Department to regulate in the first place, and whether you think there's arguments about whether that grant is broad enough to do what the agency has done in the 2022 rule.
So I think, to answer the first question, as we mentioned at the outset, this affects 112 million workers, 152 million workers, 12 trillion in assets. The standard for the major questions doctrine is that it's a question of vast economic and political significance. I think that $12 trillion and 152 million people is sufficiently vast to qualify for the economic significance that the court has looked to for major questions. For political significance, I mean, ESG is the forefront of a lot of hotly debated executive actions right now, are political issues. This started with the Green New Deal. There's a number of agencies that are trying to incorporate ESG factors into their rulemaking and into their agency regulations. So this seems to be actually one of the forefront political considerations in a number of contexts that actually pervades the entire administrative state. So that seems to qualify as well, that this would be of political significance. I would also add that in this particular context, you have Congress who has now specifically said unequivocally that this is a political issue, that whatever the agency is doing is sufficiently political that that Congress has mustered its machinery to push a vote and to force the president to exercise the veto power. I think that if there was ever an indication that something is sufficiently political that it should be decided by the political branches, it's an actual affirmative statement by both houses of Congress. So to the extent those, when you look at those factors, either individually or collectively, it seems pretty clear that before the agency can be weighing into the ESG realm, it needs clear statutory authority, which there's nothing in the statute that would suggest it has that ESG. It also raises a question about whether it has authority to promulgate a tiebreaker rule. Because first, we feel very strongly that the plain language of ERISA says you have to have single-minded devotion to your participants' interests, that you can act solely in those interests, that it doesn't leave wiggle room for these collateral considerations. But even if it did, we're looking at such a vast economic impact, we're looking at such a vast political impact, that it's not clear to me that a generic rulemaking authority to further the interest, to implement the terms of ERISA would be enough. And that's all that the Department of Labor has here. So in that regard, I think that settles it. The third prong, which is not in the normal formulation of major questions doctrine, but if it implicates federalism interests, it's very similar to the federalism canon. And I think just as a final point on this, there are 26 states in this. A majority of states in this country find this rule problematic and find it a political question. And if that's the case, then that would seem to essentially check every single box for the major questions doctrine to apply.
I think it's also very important. I like to go back to the original intent of lawmakers, and I mean, it's just this issue was all on their radar. There was a huge push for this kind of investing to be explicitly authorized, and Congress, despite that push, chose to keep trust law intact as the duties governing fiduciaries. And again, that makes sense. You're talking about managing other people's money. You need the highest standards you can have under the law to have that kind of trust. Okay, I think we should move towards wrapping up. I wanted to raise a pet point. If you have anything to say, you can. I just remember when I first read the proposed rule and doing a Control F for Dudenhofer. That Dudenhofer, for those who don't remember, that's the Supreme Court case from 2014. Unanimously held that when ERISA talks about benefits, they mean financial benefits. Not a shocker, but nice to have 9 Supreme Court justices say that. And then it's not even mentioned a single time in the whole proposal. Do you think there's much mileage in that fact, or is it more just somebody who was, intimately involved with the rulemaking, kind of having his own gobsmack moment?
I think this goes back to the discussion earlier about what, looking at the rule in its entire context, looking at how it compares to the old rule, and then looking at the proposed rulemaking in 2021 that led to the 2022 rule. It's the fact that the department never once cited the leading Supreme Court case on the fiduciary duties that apply to ERISA plans, suggests that the legal standard was not front of mind. It suggests that there was something else driving this rulemaking, which the department later admits was Executive Order 13990. Instead of looking at actually what the law required and as the Supreme Court had articulated it. The new rule intentionally removes the word pecuniary everywhere in the regulations. It says specifically that requiring fiduciaries to focus on pecuniary factors unnecessarily chilled ESG considerations. That argument is extremely problematic for 2 reasons. First of all, the Supreme Court has said very specifically that ERISA requires fiduciaries to focus on pecuniary factors. They focus on financial factors, and they are not allowed to consider non-pecuniary factors. So that word came out of the leading case interpreting this fiduciary duty. The department's rulemaking runs away from the standard articulated by the Supreme Court. In the proposed rulemaking, it fails to cite it and decide it whatsoever. And then in the final rulemaking, it actually removes the standard that applies. All of this, I think, points towards the simple conclusion that the concern here was not the actual fiduciary duty, it was some other motive. So when you put those 2 things together, that plays into the, do the judges are judges allowed to look at the broader context and the practical implications of this rulemaking, or are they limited to, the black and white letters of the rulemaking itself?
I feel like before we go, we need to pour one out for ERISA fiduciaries, because those listening can probably gather it is not a very fun job to be an ERISA fiduciary, because
Yeah, I mean, this is not considered to be the most exciting subject, I think, in most social circles. I don't know that. I think the few times I've tried to raise ERISA at a party or any sort of other function, I quickly lose all my friends. So, the people that have stuck this whole thing out, congratulations, or maybe you're just like us, I don't know.
Well, so last question, Jared. I just wanted to end this with what is plaintiffs' desired result from this litigation? And last but not least, what do you think is the chance that this gets all the way to the Supreme Court?
I think that the plaintiffs have asked the court to vacate the rule. That's the default rule, or that's the default remedy under the Administrative Procedure Act. And in our view, the rule is unlawful. It violates ERISA, and its various provisions, when viewed as a whole, are arbitrary and capricious. They all point towards furthering this idea of ESG investing, or the consideration of ESG factors with fiduciary alongside their fiduciary duties, rather than sticking strictly to maximizing financial gains. And that just, I think, on that point, relatedly, that as we talked about earlier, the entire premise of this rulemaking is that ESG investing was chilled, that fiduciaries felt that they weren't able to consider these factors, whether because they were financial or otherwise, and that they needed more flexibility in the tiebreaker rule as well. If we take the Department of Labor at its word that the fiduciary duty hasn't changed, that they were just changing the language to try and get rid of this chill, but the fiduciary duty is the same, then that means that the exact same standard applies now than applied in 2020. And if the same standard applies, and if a court's going to apply the same standard, it could look to either rule to get that standard. And the chilling effect should be the same. No matter whether you change the rules of that regulation, if you come out and say these rules mean the exact same thing, your fiduciary duty hasn't changed, it's the same chill. The entire premise of this regulation seems to be some sort of paper facade behind which the rulemaking actually took place. And so, when viewed in that manner, the way to remedy this is to vacate the rule. Additionally, if you apply ERISA's factors, the answer is you vacate the rule. So that's the relief that the plaintiffs have requested. Whether or not this makes it to the Supreme Court, I think only time will tell. I try not to make a habit of predicting that far down the road in litigation. So at this point in time, the plaintiffs are focused on the district court, and we'll cross the other bridges when we get to them.
Fair enough. I'll just offer that I would be very gratified if one day the Supreme Court says the tiebreaker rule violates ERISA 404, because that is a pet peeve of mine, the tiebreaker rule. Okay, well, thank you so much, Jared. This has been great. I've enjoyed our conversation. And with that, I'm going to turn it back to Sarah.
Wonderful. Thank you. Thanks, Brett and Jared, for sharing your time and expertise with us today. And to our audience, thank you for tuning in and for sharing so many engaging questions. You can find more of our content on our website at regproject.org, or follow us on any major social media platform at FedSocRTP to stay up to date. With that, we are adjourned.